We continue with the conversation on the ongoing Electoral Court proceedings. We're now joined by Tselane. He's the Executive Chairperson of the Institute of Election Management Services in Africa. Good evening, Mr. Tselane. Thank you very much for your time.
Good evening to you and to your viewers, and thank you very much for having me.
No, it's a pleasure to have you with us as always. Now, we've heard some strong arguments on all sides thus far. The IEC's legal representative in particular stating that the election timetable is not cast in stone. If there's an order in favor of the political parties, they would duly comply, meaning a possible postponement of elections because they would have to go back to a timetable, or rather in the timetable, to the point where candidate lists could still be submitted. Your views on what we've heard thus far?
I don't think it is possible for the election date to be postponed. The election date has been determined in terms of the Constitution, Section 49, subsection 2 of the Constitution, which determines that the elections have got to be within 90 days after the date of the last elections. Even though there are still few more days left before the 90 days expire, the president has made a determination on the date of the elections. So whatever the IEC could do, they would have to maneuver within the current election timetable with the understanding that the election date will still be on the 29th of May. Mm-hmm. So the date of the elections is unlikely to change. And if they believe that there is a possibility to maneuver through the election timetable, even though the election timetable is currently legal because it has been gazetted, but they've got the power over the commission has got the power over the election timetable because they are the ones who, after the proclamation of the date of the elections, who would then gazette the election timetable with all the milestones that have got to be achieved before the elections.
Mr. Tselane, I don't believe that they believe they still have time to maneuver, but they were probably trying to drive the point home to the justices that at this point there would be serious implications. It's quite difficult and so far within the timetable.
Absolutely. I mean, if you look at the kind of the things that have got to be done before the date of elections, things are very compressed, they are very tight. There is no possibility of maneuvering. But like I've said, at the end of the day, the election timetable is gazetted by the commission. And if the commission believes that they can, then we would have to believe that they can. But as far as I'm concerned, almost everything that is there in the election timetable is cast in stone, because once you fiddle with one aspect of the milestones within the election timetable, then all other aspects are going to be affected, and it is going to put pressure on the date of the elections. And I'm not too sure that the country and the commission itself has got the luxury of that.
Now, if we had to single out one party that crystallized a collective issue of the failure to meet the deadline for uploading of data on the portal, it's the Labour Party. They say the system malfunctioned. They raised the fact that it's the first time the portal is being used and that there was always that strong likelihood of it malfunctioning on the final day when everyone is attempting to upload their data. What do you make of just that argument?
Of course, it's not true that it's for the first time that the portal is being used. It has been used in the past. I think for the past few elections, political parties have been using online registration. And they may be the newcomers. And therefore, as the newbies, they probably don't understand the process. They did not understand how the system operates. But they did not necessarily have to rely on that portal if they felt that they could not deal with the issues that they were facing or the challenges they were facing. They could actually present that to the commission, and the commission would then have the responsibility of having to capture that information on time, but they would have to submit that information before the expiry of the date within which they're supposed to be submitting all other information.
You mentioned a very important point that they, as newcomers, perhaps were unfamiliar with the process, and that's one point that one justice raised. And she actually stated this and asked the IEC's legal representative that perhaps was there still more that could have been done to familiarize these new candidates with this process, and was there enough communication? But the IEC stated that no, there was enough communication, and at any point they had access to the IEC and could have asked questions, because even when there was the possibility for them to hand deliver the data, they waited until 4:30 with a deadline of 5 o'clock. They waited until 4:30 to drive from the Sandton Convention Center to Centurion, and of course they missed that deadline. So they say all of those possibilities and alternatives were available to them, but all they had to do was ask. Do you believe enough was done, or the IEC communicated enough even in their workshops with some of these political parties?
My issue has always been the fact that given the kind of the challenges pertaining to these elections, the election date would have been towards the end of the most possible date within which the elections can take place. In other words, I had previously suggested that the elections should actually be on the 31st of July in order to be able to allow all the participants an opportunity to deal with the issues that they're supposed to be dealing with. I had taken in consideration some of these challenges, but obviously the date of the elections was determined as the 29th of May, and then now there are all these kind of difficulties and challenges that are there. But outside the determination of the date of the elections, there isn't much that could have been done within the specified period.
Then to the MK party, Mr. Tselane, they're appealing on 3 grounds. The first being the failure of the IEC to give reason and due notification for excluding Mr. Zuma, but we understand that the IEC attempted to communicate, but the email address typed was incorrect. Does that then render the whole process procedurally unfair, as they state in their papers?
Well, that one is going to be a determination that is going to be made by the Electoral Court, having taken into consideration quite a number of factors. But it is one of the most important factors that obviously if you are taking a decision against a political party, you've got to notify them on time in order for them to be able to respond and deal with the issues that have been raised, timeously. And I think it's a matter that we will then have to see how it is attended to by the Electoral Court.
And then we also have another situation where they're saying the third respondent says he didn't lodge the objection. His emails must have been hacked. Where does this place this whole thing if the person who is alleged to have objected says that it wasn't me?
It's a very interesting one because in terms of the Section 30 of the Electoral Act, which basically provides the objections for candidacy of individuals, even the Chief Electoral Officer can object against the candidacy of any person. Now, if indeed there were grounds, and those grounds were strong enough, it would mean that it would not be dependent on a person who is from outside objecting, that the Commission would have sufficient information, and that sufficient information would be on the basis of the fact that they have done due diligence on each and every candidate amongst the 15,000 candidates who have applied to be part of this process. But as it is raised, I doubt that, in fact, the Commission has done any due diligence, and therefore they would not have the report to indicate the status of each and every individual who is a candidate as to whether they comply and then they're qualified to be candidates in these elections if they are using Section 47 of the Constitution. And then I've got also my doubts that Section 47 is applicable in this case, because Section 47 specifically deals with membership of the National Assembly and not necessarily candidates for rather in an election. And candidates in an election are defined if you go to the definitions in the Electoral Act, it will indicate that candidates for the elections are candidates as in terms of Section 27 of the elections, which is basically meaning the 15,000 people who are actually contesting the elections. So there are many provisions within Section 47 which have got exclusions, such as if you are a teacher, you are in an employee of state, and it's not only about the issue of whether a person is actually disqualified in terms of being having been convicted.
Mr. Tselane, what an interesting conversation. Most certainly a very interesting case that is unfolding tonight. Thank you very much for your insights. That's Tselane. He's the Institute of Election Management Services in Africa's Executive Chairperson.